with me Andrew Clapham, who is a professor at the Graduate Institute in Geneva. And this is a bit of a homecoming, since Andrew was a graduate of the European University Institute. And we even worked together a little bit on the Academy of European Law. One of the most interesting things you've done in recent times was to come out with a new edition of Brierly's Law of Nations. When I was a student, it wasn't a book from which we studied in the sense of, for the next tutorial you have to read this or that, but it was definitely a book that all of us were told we should read from beginning to end. And so how has it been to rewrite Brierly's Laws of Nations? What's come out of that?
It's been a fascinating experience for me, and I've enjoyed talking to a lot of fans like yourself, but others who are really quite passionate about the book, who feel that it's really the one that, as you say, if you read from beginning to end, you get a sense of what international law is all about. And that was why I was so keen to update it, because unlike many other law books, you can read it from end to end, and I found myself reading it once through on a flight when it was the only reading material I had. So I've tried to keep it readable, and updating it was tricky in parts because Brierly finished his last one in 55, I think, and a lot has happened. But I didn't want it to be my edition, so I wanted it to be as if he was writing today for a modern audience. So I negotiated with Brierly in my head whether some bits could come in and whether some bits could go out and whether other bits could be radically reversed 180 degrees. So it was a big adventure for me, but it also made me think about what's changed in the last 50 years radically.
Here's an unfair question. Would you still recommend students to read the original Brierly?
The original. I think a contemporary student would have difficulty. I found myself changing just about every sentence because the formal English of an Oxford law professor, and remember he wrote the first edition in 1928, and he didn't change any of the text, he just added bits and pieces as he went. It's quite stilted, to be frank, and so I did give it to my students to read in its old form, if you like, and I'm not sure how well they got on with it. Bearing in mind, I'm teaching students who are mostly non-English mother tongue, and so some of it is a bit archaic, I would say, to be frank.
But in terms of the content, what about colleagues? Let's forget precious students. Our colleagues who know everything, seen everything.
I would say they should read the new edition, to be very blunt.
It was an unfair question.
Yes, and to be frank, I don't think there's anything in the earlier editions, unless you are a historian of international law and you really wanted to know what Brierly thought between the wars, that would speak to you that I haven't kept.
Was there a challenge of voice? If one reads it, is one reading Clapham or is one reading Brierly?
I'm hoping one would read Brierly if he was really concentrating on how to communicate in the 21st century. I don't think my voice is very present. From time to time I'm a bit more explicit that it's me, and at one point I played with the idea of writing my own bits in bold or in italics, but that was a disaster. So I think it's Brierly's voice, to be fair. That was my intention.
What are the biggest challenges in terms of content? I could imagine, for example, that state responsibility, as we understand it today, was not even on Brierly's radar. At best, it would be protections of nationals.
Absolutely.
And yet today, the heart, the lung, the liver of international law is state responsibility. So how did you deal with that?
That was a tough one. I had to really introduce a whole new chapter without calling it that. So that was difficult, but I didn't feel I needed to go into too much detail. The bigger problems was where he had taken almost a diametrically opposite view to where I felt we needed to go. For example, the early editions say how a state treats its own citizens is not a matter for international law. So of course we had to introduce human rights law, and then the question was how far to go. So one of the interesting things with someone like Brierly is that he did leave quite a trace. So I went through the verbatim records of the International Law Commission, and you get a sense as to how he might have reacted to new topics, even if they're not in his introduction book. Another area where we had to turn it 180 degrees was, pretty sure, from memory now, he said something like, you can acquire territory by force. This is obvious. And things have moved on, and so I had to work out how he might have attempted to adjust his opinions.
What was the last edition that he himself?
The fifth in 55, yes.
But there he already had the United Nations, he had the Universal Declaration, he had...
It's true. I mean, in retrospect, it's odd. When you go back through Waldock and Brierly and Oxford professors, they weren't very impressed by the Universal Declaration or even the European Convention on Human Rights. Waldock, of course, had become involved in the European Commission on Human Rights, and so he starts to explain how it works. But actually, here in the library in the EUI on the weekend, I was reading Brian Simpson's history of that period. And the Foreign Office and the British, they all thought that this human rights thing was for somebody else, but it wasn't really going to affect how they ran things at home.
But Lauterbach was a big believer in it, wasn't he?
He was, but somehow it doesn't cross over into Brierly's thinking. Maybe it's an Oxford-Cambridge thing, I don't know.
Right. Well, you remember that nasty comment about Lauterbach in the House of Lords when he was appointed to the International Court.
There's something pretty xenophobic, because I remember that.
So maybe that had something to do, you know, these foreigners who believe in human rights. So what other normative biases did you find?
I mean,
which are not connected simply to the development of international law?
Well, the one I was thinking of, till you qualified that, was he did write an interesting article, Why We Do Not Need an International Criminal Court. And I suppose he wasn't very keen on new institutions or thinking that international law was about building a world governance system.
Some people still ask that question.
Yeah. So a lot of those sort of rather cautious attitudes prevail. I think he thought it was a way in which states got on with things as opposed to a way of controlling states, and he felt that big powers would do things and one shouldn't expect international law to control them, and I think now things have changed, or some of us think that it should have changed. Yes.
When I think, because I have my edition of Brierly, and I did read it as a student, and I took a peek at it before interviewing you, and it's hard to remember what I thought years and years ago when I read it for the first time. But I thought the great achievement was not necessarily his profound ideas on this or that, or his specific ideas on this or that, but a marvelous capacity to pack the whole thing in to a really short little book and give you a sense of the whole.
Mm.
I used it as my last reading before I took my exam in international law, kind of the feel, here's the whole.
Mm.
And
yes, I made some play with that. There was a book review done of one of his editions by someone who said that there was a rumour going around, I think it was Oxford, that if you read the whole book the night before your law exams, you couldn't fail to pass. That somehow, if you read that, you understood how international law works. And I agree, that is, I hope, still the great plus of it, that he's not so interested in the detail, he's interested in showing you that this is what it's all about, and that's what first attracts me to it. And also some of the language, which I've tried to keep, or the approach of just communicating the idea very directly.
And that's what the new book does too. This is how international law works, even though it's a very different international law to the one that Brierly.
I hope so. I mean, other people will have different visions on how international law works than what I've tried to do is his updated vision, but I hope it's there. Of course, there are big gaps, and nobody's really had a go at me about it, so I'll be the first to admit that there's not much on environmental law, there's nothing on trade law really to speak of. But I had to just consider those things together with the detailed regimes of human rights and the laws of war and things like that. It's just for another book. It's really about how the skeleton, to use a sort of Nina Cassese expression, of international law would work.
I know, beloved Nilo, but any time EJIL got an article on international trade, he would send it down to me and say, this is your stuff.
Mm.
And B, you knew, he thought, this does not even merit going into the European Journal of International Law. Is it really international law? So that view is still out there, I suppose.
I think it's probably a generational thing. I mean, I grew up obviously under him thinking, you know, that some of these are peripheral topics towards...
There's also a normative dimension in it. Human rights, use of force, that's what good people do. International trade, that's what bad people do.
Well, you said that, not me, yes.
Would you still recommend the new Brierly for students to read the night before they take the exam?
Well, I would have hoped they would have read it. Actually, I think I recommend that they read it before they start their international law course, because if you understand that going into international law, then you've got a better chance of understanding how it all fits together. But of course, if they haven't already read it, I'd definitely tell them to go out and buy a copy or download it on Kindle.
But that sounds right. That's indeed what I did. It was the first book of international law. I read cover to cover. I'm trying to think what other books of international law I've read cover to cover. That's not something we lawyers do very often, do we? We sort of dabble, we read parts, we read introductions, this chapter or that. And then I also remember reading it the night before the exam. I did do a good exam, so...
Well, rest my case.
So you rest your case. Thank you very much, Andrew.
It's been a big pleasure. Thank you.